Greetings and welcome to The Law Merchant, Part 2. Before we get started, I want to get back over to where we left off last time, as making the clarification between the synonymity between the words positive law, subjective law, procedural law, adjective law, that they all stem from positive law, which is the only law that allows slavery. In those words, do you see the statements? Hang on a second. In those words, do you see the statements as addressing free people, or do they sound like a system of commands and prohibitions for slaves? And this was referring to the various case holdings, definitions from Black's Law that we are going over, the Administrative Procedure Act, and the last one to give actual citations of what I just referred to. The legislature could not, by adopting the Code of Criminal Procedure, change the substantive law of the state, because no such authority was conferred by the Constitution. So by adopting a Code of Criminal Procedure, they cannot change, they could not, by just adopting a Code of Criminal Procedure, change a substantive law of the state, because no such authority was conferred by the Constitution. That was the only substantive law of the state. They point out the difference between substantive procedural law, saying that as relates to crime, substantive law is that which declares what acts are crimes. So this is saying the what, and then prescribes a punishment for committing them, the penalties. Procedural law is that which provides or regulates the steps by which one who violates a criminal statute is punished. So this is your due process. A statute relating to criminal procedure is a law, but not a substantive law. So a statute is procedural law. The term law includes substantive law and adjective law, or the law of procedure. So adjective law is the law of procedure. Substantive law, speaking broadly, is that which creates duties, rights, and obligations. So instead of natural rights, substantive law is that which creates those rights and duties and obligations. It orders and permits and forbids and announces rewards and punishments. As relates to crimes and offenses, it declares what acts are crimes and prescribes the punishment for committing them. Adjective or procedural law is that which provides a method of enforcing and protecting such duties, rights, and obligations as are created by the substantive laws. As relates to criminal prosecutions, procedural law includes within its meaning whatever is embraced by the three technical terms, pleading, evidence, and practice. And as we said, if you unpack these three terms, they're quite voluminous, as I've done, I think, over 20 episodes of American jurisprudence just on the law of evidence. So in those words, do you see the statements as addressing free people? Or do they sound like a system of commands and prohibitions for slaves? Do free people... So a second here. Do free people knowingly authorize a servant legislative body to adopt a code? The public servants, a servant legislative body to adopt a code that will grant them rights and creates obligations? This is the law merchant and how merchants control nations. So now we're on to the beginning of this episode here with Chapter 4, Foundation for Law Merchant Principles. Let's jump over here to the chat. Disciple of the Messiah 1, greetings. Long time. Glad to see you here. This is a real foundational one here we're going over tonight, and it is actually the foundation of Uniform Commercial Code, as we'll see. Bill Thomas says, for information and entertainment purposes. Yes, now that we're getting on to this part, thank you for that. I'd like to just remind everyone that this broadcast is strictly for the entertainment and educational purposes of the YouTube channel only, not to be used, misconstrued, or abused for anything personal, private, business, financial, legal, lawful, tax, or otherwise. So please don't do this at home. All right, now we get that covered. Thanks again. And also, if you just arrived, please hit the like. Make sure that everyone knows that we are here. I see notifications are thin as always, but that's good that the people here are going to learn a lot tonight. In the last section, we found a number of commercial terms that all work together regarding an environment where people appear to be subservient to a political superior or corporate sovereign, acting as a government. We have seen how it is possible for the great merchants of the earth to obtain control of a nation. For the great merchants to work their magic in controlling as much of the earth as possible, they need to create the proper conditions. It is like leveling the ground so the foundation can be built. It would seem all aspects of the de jure American system have changed, but all these items will not be addressed here. One thing that is obvious is the great merchants prefer democracy rather than a true republic, where the highest authority remains with the people. The point is, however, to make it appear as though nothing has changed. So the point is to make it appear as though nothing has changed, although appearances can be deceiving. If voting changed anything, then make it illegal. Emma Goldman. It is enough that the people know there was an election. The people who cast the votes decide nothing. The people who count the votes decide everything. That's from Joseph Stalin. A free America means just this. Individual freedom for all, rich or poor, or else this system of government we call democracy is only an expedient to enslave man to the machine and make him like it. Frank Lloyd Wright. Wow. All right, we're on to Chapter 5, Security Interest and Court of Equity. Let's jump over here to the chat and make sure we're up to date. Okay, seems good with that. Let's get started. The following case will provide a microcosm scenario of how creditors can control a government by having a security interest. but yet they are outside the government and possibly above the government, directing its legislative and executive acts. As shown in the following case, courts of equity are the principal tribunals for the merchants. The city of Parkersburg, in the following quote, which had issued bonds to bring in money to benefit manufacturing, had certain property deeded to it as security for the bonds. Issued bonds to bring in money and had certain property deeded to it as security for the bonds. Let's see here. The bill alleges that the deed of trust to the city was executed for the purpose of securing the holders of the bonds and coupons, and they are the parties beneficially interested in the same. And the city is a trustee of all the property mentioned in the deed for the holders of the bonds. That the city was bound to care for the property and protect the title to it for the benefit of the Sestui Trust, and especially as it had induced them to purchase the bonds. Wow, okay, so let's see here. This is what the bill alleges. That the city was bound to care for the property and protect the title to it for the benefit of the Sestui Trust, and especially as it had induced them to purchase the bonds, as well in reliance on the deed as on the credit of the city, that the city was, as trustee, bound to interpose to prevent the sale of the chattels. That the owners of the bonds are entitled to the interposition of a court of equity for the care and protection of the property, and to decree for the sale of such of it as remains upon the premises mentioned in the deed to the city, and for the sale of the real estate. Yikes. Well, that's a bit to unpack here. And this is the city of Parkersburg versus Brown in 1883. If we replace the word city with the word government, we can more easily see how this scenario can apply to many more situations, like a state or nation. Let's see here what they mean by that. So the underlined are for their emphasis of the author. That the deed of trust to the state, we could say here, right, to the government, was executed for the purpose. And the government is a trustee of all the property mentioned for the holders, and that the government was bound to care for the property. That's what they're saying here. Interesting. The premises mentioned the deed to the government. All right, so the monetary system operated by the Federal Reserve, as well as Federal Reserve notes, are based upon debt, including bonds and other securities. What is collateral? What is backing the debt instruments and digits used as money? Hang on a second here. Okay, Bill Thomas says here, I wonder if Parkersburg was a company town that was organized around an activity like mining. That's a curious question there. We'll be able to answer right now, but if anyone in the chat wants to look that one up quick and pop it back in there, we'll readdress that. Thanks, Bill. All right. So what is collateral? What is backing the debt instruments and digits used as money? It must be freedmen, quasi-slave U.S. citizens, and their property. There will be remarks on this later, and I will say that in the Federal Reserve Act of 1933, and I might be able to pull that one up rather quickly here, because this would be an important aspect to, one moment here, to bring up, because as he's mentioned it here, and they might get into it, but I can't say for sure that they will. So that being the case, let me see if I can pull this up really quick here. and that was the Federal Reserve Act. Practically, the war powers were given back in 1917 with some slight amendments. The other gives supreme authority to the Secretary of the Treasury of the United States to impound all the gold in the United States in the hands of individuals, corporations, or companies, for the purpose, I suppose, of bringing together that gold and making it available for the issuance of Federal Reserve notes. Third section deals with how banks are to be handled under this authority, how bank assets are to be frozen, and deals with the question of limited receiverships and receiverships. The last section of the bill provides for the issuance of a new money. I'm a little at a loss in a hurried way to have read the bill, and I understand just how this new money is to be handled. I refer to Section 401, which reads, upon deposit with the Treasurer of the United States, of all contract obligations of the United States or any notes, and so forth. Under the Federal Reserve Act, obligations that are deposited as security in gold for reserve notes are placed in the hands of the Federal Reserve agent. I would like to ask the chairman of this committee if this is a plan to change the holding of the security back of the Federal Reserve notes to the Treasury of the United States rather than the Federal Reserve agent. And Mr. Stiegel, this is from the famous Glass-Steagall Act, right? This provision is for the issuance of Federal Reserve banknotes, not for the Federal Reserve notes. And the security back of it is the obligations, notes, drafts, bills of exchange, bankers' acceptances outlined in the section to which the gentleman has referred. Let's see, this goes on here, but there is one part that we got to get to where it mentions about the collateral. Here we go. It would appear that the amount of bank notes that might be issued by the Federal Reserve System is not limited. Ha ha, no kidding. That will depend entirely upon the amount of collateral that is presented from time to time for exchange for banknotes. Is that not correct? Yes, I think it's correct. Oh, look at this. So that it might run to was this 20 billion. That's all. Mr. McFadden, in the discretion of the President and the Secretary of the Treasury, these notes are to be secured by assets that are approved, that are turned over by financial institutions to the Treasury of the United States. Applause. Yeah, it's great. Mr. Stiegel, Mr. Speaker, I yield 3 minutes to Maryland. Mr. Goldsboro, oh, what a name. Mr. Speaker, in a time of storm, there can be only one pilot. In my judgment, the House of Representatives realize that the pilot in this case must be the President of the United States, and they will steer their course by him. Mr. Speaker, in my deliberate judgment, under the leadership of the President of the United States, there will shortly be brought from Committee on Banking and Currency carefully considered legislation ensuring the depositors in all banks, yeah, sure, carefully considered legislation I want the people of this country to have currency and mediums of exchange with which to do business. Yeah, this is the medium of exchange I keep talking about here. And this is the new money, as we say, a turning point. We're at the bottom of a pit. I love it. And we have the suffering and poverty and the usual appeals to emotion. And I'm not sure if I can actually search through this through this document here. Let's see here. Under the new law, the money is issued to the banks in return for government obligations, bills of exchange, drafts, notes, trade acceptances, and bankers' acceptances. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation. Here it is. It will represent a mortgage on all the homes and other property of all the people in the nation. So we finally found it here. This is the part we've been looking for, and we finally found it. So let's read this one more time. This is the expansion of currency necessary. If the Republican Party had released itself from the clutches of Wall Street and expanded the currency immediately after the stock market crash in 1929, remember this is being written in 1933, or within a year after the crash, our people would have been saved from this awful money panic. Our president will doubtless ask amendments to this new law when conditions are more normal and when it is better understood. Under the new law, the money is issued to the banks in return for the government obligations, bills of exchange, drafts, notes, trade acceptances, and bankers' acceptances. The money will be worth 100 cents on the dollar. These are your Federal Reserve notes instead of Treasury notes because it is backed by the credit of the nation. It will represent a mortgage. Debt instruments, right? It will represent a mortgage on all the homes and other property of all the people in the nation. The money so issued will not have one penny. Penny? We don't have pennies in America, we have cents. Well, see, it says 100 cents on the dollar. We don't have pennies in America. Pennies are British. Who's this speaking? The money so issued will not have one penny of gold coverage behind it, because it is really not needed. We do not need gold to back our internal currency. We only need gold to settle our balances with foreign countries. Our people do not actually use gold as a medium of exchange. Paper money is just as good and is much easier to handle. However, if gold is desired as a backing for paper money, we have a sufficient amount to permit issuance of $5 billion more money and still have a gold reserve of 40%. When England paid us approximately $100 million in gold last December, oh geez, the Treasury should have taken that gold and issued $250 million in paper money. Using the gold as a sufficient coverage of 40%, and the money should have been put into circulation by paying it to government employees or other governmental debts. Jeez. Instead, the gold was delivered to the private banks, and the government given credit for this amount. The banks used a part of it as a base to issue considerable money, which they loaned to their customers, and the remainder, which was most of it, was sold back to England by the bankers. The gold that is given up by the people in the present crisis should be delivered to the government. It should be used to issue additional money upon which the people will not have to pay interest while it is in circulation. Interesting here, and I'll leave it here before we digress any further from that. Let's see what we got here. Bill Thomas says, shocking indeed. I recall this from a previous one I did actually last year, around the time that this was written as its anniversary in March 9th. And public lands, indeed, all the land in the United States mortgaged for these Federal Reserve notes. And you read it here, it's not my words. Remember hearing the future of cents were in doubt, at least as a coin, perhaps. It was just the language here caught me by surprise because you figure even at that time there was still a bit of anti-British sentiment. You know, it's never really been our friends after the declaration. All right, I digress. Once again, let's get back to the main program. I appreciate you all for sticking with me through that. And as they say, we'll have remarks on this later. Well, we just had plenty of remarks on it right now. Let's get back to this. There we go. Okay. So what is collateral? What is backing the debt instruments and Digits uses money? Well, we just went and did our research, and let's see what this text says. It must be freedmen, quasi-slave U.S. citizens, and their property. There will be remarks on this later. In the simple example above, a deed of trust on real estate is the security for the bondholders. When bonds for raising revenue are issued by a government, the government becomes a trustee for the bondholder or creditor. The bondholder is a cestui trust. Cestui trust, meaning a fiction has a beneficial or security interest in whatever is backing the bonds. In the example above, the security was a deed of trust to real estate, and it says on the credit of the city. We saw here on the full faith and credit of the nation, right? As we said, we can use government, nation, city interchangeably typically on these statements, which means other items of value the city has an interest in or sources of revenue may also be used to satisfy a claim by the bondholder. And as Bill Thomas is saying, I think that answers that question. If the city has an interest in it. Okay, so one thing here that I think we need just for clarification here, and I don't want to be giving my interpretation, but we could look this up in Black's Law just so everyone here that's on the live stream can know exactly what it means. I hope it's not under trust, but we'll look under the C's first because we are there. Again, this is a scanned document. Takes a while. Here we go. Catch up with where we scan to. All right, we got to jump a little more than that. A lot of COs. Geez, civilians too. All right. C words in black. So say, here we go. Oh gosh. I have a feeling it's going to be under trust, but we got to look here first because we're in C's. Sesquiquo. All right. Oh, it's SETI or SESTWI. All right. SETI sounds better, huh? SETI key. 7K. All right. SETI key use. And this is SETI V. SETI use. SETI V. Or SETI trust. SETI trust. Here we go. It's on screen. Or SESTWI trust. SESTWI trust. I hate Latin. All right. Actually from French, so I guess I can't say anything about Latin on that one. Yeah, I hate French. SESTWI trust. One who possesses equitable rights in property. Equitable rights, usually receiving the rents, issues, and profits from it. Beneficiary, also termed fideicommissary. Fideicommissarius. Okay. Let's read this one here. An alternative name for the beneficiary. Oh, an alternative name for the beneficiary is SESTWI trust. An elliptical phrase meaning he for whose benefit the trust was created. In this phrase, SESTWI is pronounced SETI. Sorry. Okay. SETI. In this phrase, SETI is pronounced SETI with the accent on the first syllable, SETI. And key is pronounced key as and trust as in English. Boy, it's been listening to me here. So it's SETI trust. Grammatically, the plural should be SETI trust. What's the difference here? Pronounced like the singular, but by an understandable mistake, it is sometimes written as SETI trustant, as if trust were a verb. So it's got the S, but you don't pronounce it when it's plural. It's pronounced like the singular. So that's, I guess, the key thing to sound like in your erudite is you always pronounce it SETI trust, even if it's plural. But if it's plural, you'll add that S after the SETI so that it's in the plural noun. Okay, so I think we did, it's another name, alternative name for beneficiary, and it's an elliptical phrase, and it's French. And I do not speak French. So let's continue here. All right. Interact. There we go. The bondholder is a SETI key trust, meaning a fiction has a beneficial or security interest in whatever is backing the bonds. In the example above, the security was a deed of trust to real estate and, it says, on the credit of the city, which means other items of value the city has an interest in or sources of revenue. Parking lots may also be used to satisfy a claim by the bondholder. The bondholder can make demands on the government, perhaps write legislation for the legislature to adopt, respecting the care for the collateral property and for protecting the title to the property. They can make demands. Interesting there, huh? That the bondholders making demands on the people's government. Okay, oops. Sorry about that. Let's continue here. See how we are in the chat. Everyone's still along with us. Let's continue. So, bondholder making demands for legislation to protect the title to the property, the collateral property. In the case above, some movable items, chattel, were being taken from the structure on the land represented by the deed of trust. So those are appurtenances. Appurtenances. Bondholder as a SETI key trust, believing the items being removed were part of his security or collateral, went to a court of equity to enforce his moral and equitable right. Technically, the bondholder is not the owner of the real estate. Does have legal title, and does not have possession. The bond is a chose in action. But the city has a moral obligation to the SETI key trust bondholder, as explained above. The rights and remedies of the bondholder were not within the jurisdiction of a court of law, but a court of equity can deal with the beneficial interest, securities, and collateral regarding equitable rights and equitable remedies. It is possible that courts of equity are an invention of the great merchants. Now, we didn't have courts of equity in England. There were chancery courts, which were basically non-real judicial type of courts, but they dealt with these matters here. Remedies, beneficial interests, and securities and such. The case was in 1883. The city of Parksburg was a corporation, and the inhabitants could be viewed from a legal perspective as freedmen, villeins, quasi-slaves, also known as U.S. citizens, and as such subservient to the corporation, city, as actual or potential taxpayers of the corporation. The bondholder could view them as potential sources of revenue for the debt, depending upon the local laws in existence at the time and the terms of the agreement regarding the bonds. Boy, think about that next time they're proposing bonds in your locality. That the legislature may lawfully authorize municipal corporations to subscribe to the capital stock of railroad companies, and that such authority may be given to the corporate authorities, or it may be made to depend upon the assent of a majority of the incorporators. The authority may rightfully extend to the issuing of corporate bonds for the payment of the subscription, the interest and principal of which is necessary to be paid by taxes assessed upon the persons and the property of the taxable citizens of the corporation whose faith is pledged for the redemption of the bonds thus issued. Jeez, that's from 1853, Sharpless versus Mayor of Philadelphia. Whew. Does a municipal corporation fit into the plan of Republican forms of government? No, but they fit the needs of the law merchant and sovereign rulers. Does municipal corporation fit into the plan of Republican forms of government? No, but they fit the needs of the law merchant and sovereign rulers. The corporate authorities of the municipal corporation may issue bonds to raise money to pay for the subscription of the capital stock of the railroad company and then assess the persons and property of the taxable citizens of the corporation, which is a people still referred to as a city or government, even though it's a corporation, so the corporate authorities can receive the necessary revenue. Or they may put it to a vote, democracy, where a majority can also place taxes on all taxable citizens of the corporation. How can your neighbor agree to put a debt on you, on your land, without your consent? Of course, that is a type of question a true free man would not ask. That's the type of question a true free man would ask, but not a quasi-slave. A municipal corporation is a body politic and corporate, with socialistic and communistic foundations. This is a corporate system of great merchants needs. This is a corporate system the great merchants need, so they can apply their trade regarding banking, loans, national debt, substantive or commercial duties, and rights, obtaining beneficial interest in persons and property of such corporations, developing a slavish citizenry, developing prisons, creating revenue, and controlling nations. Also in the Sharpless case, we find the following remarks. There is nothing more easy than to imagine 1,000 tyrannical things which a legislature may do, if its members forget all their duties, disregard utterly the obligations they owe to their constituents, and recklessly determine to trample upon right and justice. But to take away the power from the legislature because they may abuse it and give it to judges the right to controlling it would not be advancing a single step, since judges can be imagined to be as corrupt and wicked as legislatures. In Norris versus Clymer, Chief Justice Gibson, with characteristic directness of expression, declares that the Constitution allows the legislature every power which it does not prohibit, that the law then in question was valid, because there was no syllable in the Constitution to forbid it, and that if a law, unjust in its operation and nevertheless not forbidden by the Constitution, should be enacted, the remedy lay not in an appeal to the judiciary, but to the people, who must apply the corrective themselves, since they had not entrusted the power to us. Wow. It's more from Sharpless. Constitutions were written to provide limited government, limited only to delegated authority. If you advance the idea that constitutions only restrict governments, that is to say, a government may do practically anything unless the words in a constitution say it cannot, then you have lost a major component of republican forms of government designed to safeguard the liberty of the people and to keep government off the backs of the people. If government is unleashed from the chain that hold it in check, the liberty of the people will suffer. It takes us on to part 6, chapter 6. Check up in the chat, make sure we're all keeping track. Let's get back. Law merchant, admiralty, and common law. The following is included merely to point out that the law merchant took over admiralty and common law. That way, you can still say admiralty or common law and not call the law by its true name, law merchant. Wow. Law merchant was the basis of the modern system of admiralty law and the laws of negotiable paper and of sales. Negotiable instruments, as we just read in the Federal Reserve Act. The American People's Encyclopedia. That's where it came from, 1968. The substantive law inherent in the admiralty and maritime jurisdiction. The sovereign power which determines the rules of substantive law governing maritime claims. The merchant class and disputes among its members arising out of commercial transactions were not subject to the common law. This practice grew out of the necessities of commerce and trade. Merchants traveled from fair to fair. Remember the medieval fairs of the merchants. And from place to place. But in all places, the same rules of law were administered and enforced in commercial litigation. Remember, their special courts. Later, the Admiralty courts widened its jurisdiction to embrace mercantile issues. That's Bank of Conway versus Starry, 1924. In American Jurisprudence, second edition, Admiralty, in sections 94 and 96, we find that international law basically is a law merchant. Section 94 also says that although these rules of the law merchant may in some instances seem strange to those who are versed in the principles of common law, the principles of the law merchant have been accepted in the English common law for many generations. With respect to state courts acting as courts of admiralty, the following from Amjur Second Edition says, where a state court has concurrent jurisdiction with an admiralty court under this saving to suitors clause, and the action is brought in the state court, the substantive law to be applied is that which would have been applicable had the action been brought in the admiralty court. So they're using the admiralty substantive law, right? In this case where there's concurrent jurisdiction, state court, and admiralty court. Because they know that the admiralty court now is using, where was that part there? Well, as we were just reading over here. There we go. Admiralty courts widen its jurisdiction to embrace mercantile issues. Therefore, if there's a state court having concurrent jurisdiction, right, the action is brought in the state court. The substantive law to be applied is that which would have been applicable had the action been brought in the admiralty court. So regardless of which court it's brought into, they're going to apply the substantive law, remember, the positive law for that particular jurisdiction of admiralty had they have just originally brought it to the admiralty court. That's when you have it in the concurrent jurisdiction. I think maybe also as supplemental. I'm not too sure because I'm not sure where he's getting. Oh, from Amjur. So we can look this up, but we're not going to do that. We did enough digressions tonight. That'll be for further follow-up. While a state court may not technically be an admiralty court, it may act in the nature of an admiralty court with respective to substantive commercial duties and rights. The state quasi-admiralty court would apply its state adjective law merchant rules of procedure. Rules of procedure, but the substantive law is governing would be from the admiralty court. A number of years ago, it struck me as odd to find that the states adopted the English common law, since the national English system was deemed quite distinct from that established here in the American states. When you realize how the law merchant was put into English common law, it is easier to see how it could also be a clever means for bringing the law merchant into the jurisprudence of the American states. All right, we're on to Chapter 7, the imprisonment and security interest. Let's see, we've been going on pretty long here. We're probably going to stop with this one and we'll continue on the next one with a part 3. I thought we'd get through this a little bit quicker, but we did have that digression into the Emergency Banking Act, 1933, which really gives us a better idea of where all this talk of collateral and how it's being securitized and being created into the means of control. And you're seeing how this is all actually documented. It's not just a lot of conjecture. So the text does have a lot of, we verified a lot within there. So now we can go along and see if these are logical inferences that are being presented to us. And that's up to the listener, the audience here. So far, in my eyes, a lot of this has been pretty solid. Tocqueville warned that if voters could put their neighbors in debt, they would not stop until the bones of every taxpayer was picked clean. Yes, that's right. I recall that one. Excellent. Lex Enemata, well, thank you so much for coming, and I appreciate everyone spending the time here. And please make sure you hit that bell notification to get notified for the next live stream. And we're going to continue next time with part 3 of The Law Merchant, and hopefully we should be able to finish it up by then. A lot of stuff to unpack here. I think we did a lot of good follow-up research to make sure we have a full understanding and verification of the references and the presumptions being made here, and seeing how they can be validated by the actual cases and how they've been ruled on based on this following logic of law. That being said, salute to you all for being here and spend the time learning. And I hope to see you all on the next one. Peace out.